So, hi everyone. So, in this tutorial, we try to cover up the forensic medicine in one shot. Basically, I'm going to use both to make this specific topics will be there. I'm going to cover the most important topics, the previous year questions as per the Punjab board, as per the syllabus from the Punjab, according to the military university. So in this, we will try to cover up the entire forensic only. Toxicology will not be covered in this. Entire uh, forensic medicine will be covered in this. And out of which, majority is going to be very important questions to specifically the pre-vacuum questions. Because 99% of the time, what we can see, the questions coming in the theory subjects are from these certain topics which are most important at the point. So let's get started. So very first, we're gonna start with a legal procedure in medical juro periods. Okay. So now we're gonna start with the first question. If I skip few questions, that means according to me, this question has already been dealt with, or these questions are not so important because you can see these questions once in a while, but I will not ask you to skip any of the questions if you have enough time. So you just go ahead and make sure to go through every questions over there, and please make sure to clear your 110% because trust me, it's gonna be easy, and if you will be able to clear this in your theory exams. So okay, so let's just start with professional negligence. Okay. So professional negligence, basically, there are two terms. One is professional negligence and then professional misconduct. So please make sure not to get confused in both of these terms. Both of these terms are separate. They have different definitions, different things. So do not get puzzled with both. Okay. So now, first of all, we're going to study the professional negligence. Let me give you a definition, basically. What a professional negligence is, it is defined as a lack of reasonable care or skill on the part of the doctor that result in injury or death of the patient. What basically this means is like the doctor. This session is going to be in English as well as in Hindi, so it's going to be easy for you to understand. So basically, now a doctor है. अब डॉक्टर के पास या तो उसने रीजनेबल केयर नहीं दी उस पेशेंट की या फिर doctor was not that of skilled to tackle that emergency or that situation. Okay, so we can say that as a lack of the responsible care and skill on the part of the doctor that result in injury or the death of the patient, which means either the patient is injured, okay, and either there is a death of the patient. Okay, so now what are the components of the medical notice? What are the components? So number there's a very short trick that is 4Ds. Always remember. If you see this, I've already gone through this. These are kind of my notes, so I'm just giving you a bit brief of what I have learned from it. Okay, so basically the D's are duty of the doctor, dereliction, damage, and direct causation. Now, medical negligence cannot be established until or unless all of these four conditions must be present. Which means the doctor who have allegedly done a professional negligence is the doctor on duty for the same patient. Secondly, the doctor is not abandoning the patient for some other reason, possible by some motive or whatever. The patient is not being abandoned by damage, like the damage done during this professional negligence, something happened to the patient got hurt or whatever. Okay, then direct causation, or which means the negligence that was happened by the doctor is a direct causation. It's caused directly by the doctor. Like you can say the doctor might, have an idea that this can happen, but yet he said that yes, I'm gonna do it. He might come like so until unless which are conditions of the feeling will, so you can't say the medical negligence is okay. I will repeat it again: duty, dereliction, damage, and then the direct causation. There are two types of negligence. One is civil, second is criminal. The third is also there, in which firstly the patient or the relatives of the patient filed a civil complaint, but then also reported to the patient to the police also. So it will be civil criminal negligence. Okay. Now the thing is over here that let's just know like what is a civil negligence, what is a criminal negligence. बेसिकली है क्या अभी सिविल नेग्लिजेंस में क्या होगा कि जो डैमेज है माइंड ज्यादा ग्रीवियस हर्ट नहीं है व्हाट इज द ग्रीवियस हर्ट विल डील इट इन फॉर द पार्ट ऑफ दिस लेक्चर आल्सो ओके एंड हुआ तो होगा क्या कि डायरेक्ट और डैमेज नहीं सॉरी इंजरी इज दैट डैमेज इज दैट बट इट्स माइल्ड not that threatening but still the damage is there but in the civil it is more serious. Like there can be death or serious grievous harm to the patient. Injury says what? Civil negligence में क्या है कि basically patient goes to the civil court, the consumer court, asks for the compensation as an injury, damage suffered by him can be compensated by money. Basically, patient basically क्या हुआ कि वो civil court गया या कंज्यूमर कोर्ट गया he said कि हाँ मुझे डैमेज हुआ है ठीक है ना मुझे कंपनसेट किया जाए इसके लिए so he or she may ask for the compensation but on the other hand the patient or the family reports the matter to the police okay gross negligence on the part of the doctor can lead to a serious injury that the patient gross negligence is that is either dead or there is a serious injury okay but on the other hand civil there is like mild injuries there just a second. Okay. Sorry for the interruption. Okay. So, with civil negligence, basically, punishment can be in the form of fine, no imprisonment of the doctor. There will be no imprisonment. Example can be like failure to take the consent for the government transaction. Okay. But now coming to the criminal negligence, what can be, the consequences for the criminal negligence. Basically, overhead said section 304 IPC, but now according to BNSS, it is section 106. Basically, this punishment of 2 years or imprisonment. I can be wrong. Please verify it. If I'm wrong, just drop it in the chat. Punishment due to the criminal negligence. Punishment of 2 years of imprisonment and fine. For example, the doctor was supposed to operate the left leg, but operated the right. This is a criminal. Comes under the criminal. Now coming to the second part, which is the civil and criminal negligence. Basically, the patient goes to the civil court first, or the consumer court. I also report matters to the police. Involvement of the police is also there. In this case, the medical negligence can be fought in both civil or criminal court simultaneously. Now, we know negligence has happened directly or indirectly. Whether it was your intention or not, but, negligence तो हो गया. What are the defenses that you can, produce against these cases of negligence? Okay. It's a sincere request. I'm not a teacher. I'm just teaching you from a perspective of a student. Just trying to, explain it by dumbing it down a little. Okay. So that those who are having some issues with studying, they can, at least get this easily. They can at least get an idea like what they can, it can be helpful for them to for exams. Either it's their midterm or okay. Now, defense, क्या है? Like, what are the defenses against the mechanisms? I know I'm a bit slow, but with side, मैं थोड़ा सा पूरा करूँ. So, no duty on the You remember the four parts: duty, dereliction, damage, and direct causation. जिसमें पेशेंट ने जब ड्यूटी ओन ही नहीं किया उस सॉरी अब डॉक्टर ने जब ड्यूटी ओन ही नहीं किया उस पेशेंट ओके द डॉक्टर डिड नॉट ट्रीट द पेशेंट नो ड्यूटी एग्जिस्ट बट दिस इज द नंबर वन डिफेंस अगेंस्ट द mechanism. Second is res judicata. Like, for example, that the things that have already been decided by the court, it cannot be tried again. Listen, for example, that you went to a court, they said for the compensation, but they are not, they said, "हाँ, okay, itna compensation आपको clear." But then the patient again goes to the same court, so, that compensation is not enough for us. We need a little more or whatever it is. So, over that, whatever the damage, whatever the thing was decided by the court. It cannot be tried again with the same thing. So tried नहीं होगा. Okay. Coming to the next part, which is contributory negligence. Not only doctor, even the patient is also found to be negligent. So doctor can take this in defense. For example, a very short example I'm going to tell you. आपने क्या किया पेशेंट के फ्लश ठीक है बट आपने कंटिन्यूसली एक पेशेंट को पूछना कि वो राइट तो नहीं इज दैट is not that right now because what happens is if a process is fluid, then it can create an issue with the circulation and all. So you ask the patient, he said, okay, everything is okay. But with time, उसको pain बढ़ता गया, but he never mentioned it to you. Repeated asking, like, is everything is okay, whatever. The patient never said even a single thing. But now something happened to his leg. Now he's taking you to the court for this. But over there, you can also mention this thing. Yes, मैंने इनको पूछा था कि अगर टाइट है तो बताइए कोई कॉम्प्लिकेशन है बताइए कोई और दिक्कत आ रही है बताइए they didn't say. So that comes under the contributing negligence. Remember this. Therapeutic misadventure. Therapeutic misadventure is basically occurrence of damage or mishap with the patient due to some drugs or procedure. For example, you injected penicillin to a patient who has never had a penicillin in his entire life. Never had. Okay. Now, once you injected, now you just got to know that he is, allergic to the penicillin. Now, adverse reactions started. Adverse reactions are started. Now, what you can do? You counter that, no? But during this entire scenario, there can be some damages happen. There can be some damages happening. So, what's going to happen is basically that in therapeutic misdemeanor, like occurrence or damage of mishap with the patient due to some drugs or procedure, that some drug or procedure during something happened, some mishap happened, the damage done. Okay, so that comes under the therapeutic misdemeanor. The doctor has no plan until or unless the doctor is aware of this. This thing, hypersensitivity of the penicillin, fatal complications of with blood transfusion, other example. Okay, limitation. Let me just clear it a little. Limitation. Now let's say that you have done an amputation of a left leg for a person. Okay, because that was the only uh, last point of treatment. Because okay, I have you get the image. So now after 2 years or 3 years or so, he just got to know or some of his friend or a relative said, कि हाँ, you can ask for the compensation कि हाँ, और कोई मुझे बताया नहीं क्या, whatever it is. There can be some other, there can be some other things, or there can be some other treatments that could have been asked for to the patient or presented to the patient. there is some technical thing going on, or there's some this thing going on. Then if you wish, you can try. Okay, but after 2 years or so, this thing he had some issues. Okay, and it's been 2 years since he filed a report and all. But now all of a sudden, after something happened, after some negligence happened, after 2 years, he tries and comes to file the report against the doctor. It won't. It's not going to happen. Why? Because the case against the negligence of a doctor should be filed within 2 years. Within 2 years of from the date of alleged negligence. Okay, error of judgment. Everything, every time. It's not everybody's not perfect. But whenever a doctor is judging the condition, his judgment is always to make sure that the patient gets the best treatment, or it's always in the favor of the patient. Sometimes there can be some errors. So it has been recognized by the court of law since the doctor's decision turned out to be wrong. Like he he has given his 100% that yes, I want my patient to be treated in a very well manner and all. But unfortunately, it didn't go as planned. So cannot be liable for the medical expenses. Product life, for example, you have done for the author for those who are willing to take orthopedic surgery as a profession. You have like put a plate in person in a rod in a steamer bowl. But unfortunately, that rod was defective or some issues happened due to the product, not by your procedure, but due to the product. Then you are not liable. Here, the product liability is there. Sometimes 3 or 6 marks short note can be asked from this. Uh, I think at my time, one short note from product liability. Yeah. So it's an important. Okay. So when manufacturer supplies defective drug or instrument which was prescribed by the doctor to the patient sustained injury. In this case, the manufacturer has the responsibility, not the doctor. Okay. Manufacturer has the responsibility. Now, informed consent for that. The patient was duly informed the consequences. Now, the most important thing, always take the informed consent from the patient itself. And in the informed consent, you should inform the consequences of the procedure, consequences of the medication they are taking, or treatment. So that whenever they are signing the informed consent, that they are being informed about this. Okay. Yeah. Now, coming to okay. Now, in the punishment of professional negligence, we have I have already told you that there can be fines, there can be imprisonment, but sometimes there can be warning, but sometimes there can be one thing that is penal erasure. Okay, that is penal erasure. As you can see, it is basically the removal of the name of the doctor from the state medical register as a penalty. Like something happened, okay, the court has asked the state medical registrar to remove this doctor's name from the state medical register as a penalty. Okay, that can happen. Now these are of two types: temporary and permanent. Okay. I think this video is gonna be so long, so I'll try to make sure that I'll make this as a part one, the part two in the upcoming. Okay. So temporary and the permanent. In temporary, basically, the doctor is not allowed to practice his medical profession for a specific period of time. Like he said कि हाँ आपको 6 मंथ के लिए आपको इरेजर किया जाता है, penal erasure किया जाता है. So let's say कि उसको 6 months का. After 6 months, he can restart his journey, restart his practicing. Okay, but not in the case of the permanent erasure of memory. The permanent erasure is also called professional death sentence. Periods, professional death sentence. Basically, it is a kind of a death sentence given to the profession of the that for his entire life now. you are not liable, or you will not be eligible to any or to practice. But now over here, doctor can appeal to the central health ministry or central government within the 30 days of decision, which forwarded to MNC, and the decisions appeal against the law. Okay. So I hope this is clear. This part we are covered with the professional negligence. Professional negligence. But now coming to the professional misconduct. As I already mentioned, now please make sure not to be confused with negligence and misconduct. Basically, in negligence, you know, there is a lack of a reasonable care and the skill on the part of the doctor. But in the professional misconduct, it is considered disgraceful. Any conduct on the part of the doctor which is considered disgraceful or dishonorable. Disgraceful or dishonorable as judged by professional men of good repute and competence. Anything that is done by doctor which is disgraceful, dishonorable, if we judge, when it's judged by men who have a good reputation, जिनकी reputation अच्छी है, जिनकी competence अच्छी है. So that. Now, what are the examples of this? Always remember one short trick on this. That is this 6 A's. Because I also have studied this accordingly. Okay. Now, let me give you what those 6 A's are. This also written over here also, but I will, you know, number one, adultery, advertisement, association, addiction, alcoholism, and abortion. Repeating again, adultery, advertisement, association, addiction, alcoholism, abortion. Abortion is basically legal, illegal. And then comes a other example like sex determination. But over here, sex determination is with the intention for female fetus, and then issuance of the false certificates for and then discordant. Now, let me give you, let's just cover this briefly, like what these are. Adultery is basically voluntary sexual intercourse between man and a married woman. A man can be married and unmarried, does not matter, but a woman is not. It's a voluntary sexual intercourse between man and a married woman. Advertisement. Basically, the physician or a doctor is allowed to advertise his services, but it should not be over advertised. It should not over advertise. For example, fix a signboard on the chemist shop, like there is a certain chemist shop over here. You have an association with them and you are fixing your signboard over there. Using touts or agent to procure the patient or advertise himself through the manufacturing firm directly or indirectly. Association, basically, when you are associated with unqualified person. Addiction, basically, if the doctor, it's quite obvious that if a doctor is addicted to a drugs or cocaine, for example, cocaine and speed, it's obvious that he will not be able to make any rational decisions. Alcoholism, the doctor should not practice under the influence of alcohol, which interferes with the proper practice of medicine. Abortion, doctor performing an illegal abortion against the medical ethics. There's a courtly, basically is fee splitting or fee sharing. Basically, it's giving or receiving commission from a fellow doctor or manufacturer can that ठीक है यार मेरे पास गैस्ट्रो का पेशेंट आया मैं तुझे भेज दूंगा वो सॉल्व होता है तो मुझे भेज दियो ठीक है and you are a compensation की हाँ 15% दे रहा 30% this is the kind of dichotomy that you're talking about. Then coming to the issuing of the policy certificate in connection of the sickness, insurance, passports, or public services attendance. Sex determination is with the intention of female fetus. And if a doctor does not maintain the medical records of the indoor patient for the period of 3 years, it is also considered as professional misconduct. Now, in punishment in this, basically there are two things that can happen: warning, and if serious professional misconduct is there, then penalization. I'm not going to go deep into this again. I've already informed you. It's a perfect simple sentence. It is basically removal of the name of the doctor from the state medical register. Okay. If you want, I will also attach this link to this book to the PDF. So basically, what you guys can do now, there's a clinical scenario given over here. Okay, on the basis of the above question, so you guys can just go through with this and you can have a bit more idea. Okay. So now coming to the next part, which is evidence. Hmm. What are evidence? Evidence is basically defined as legal term is a legal means to prove or disapprove any medical legal fact which is under inquiry. Defined as legal means to prove or disapprove any medical legal fact which is under the inquiry. Now, what now in second question is the procedure of recording of evidence of witness in a court of law. Now, I would like to like that to say that please now have an open mind and open ear right now, because in this what I'm going to tell you right now is basically majority of the questions in the Viva comes from here. So I would like your attention for a while over here. I want your attention for this entire session, but specifically for this part, because the majority of the question comes from this part from the in the your practical Vivas. Now, basically, before we get into this, okay, this question comes on to the evidence, like define like what is evidence? Usually, it's a legal means to prove or disapprove uh, any medical legal aspect under inquiry. Okay, it can be a oral, sorry, it can be oral or documented. Like somebody has orally said something and documented, for example, your informed consent. Okay, now what are the let's talk about like what is the procedure. Now, let's say that you are there. Now, first of all, the oath is taken by the witness. Okay, now we want the evidence. We call the witness to the court of law. Okay, now the oath is in the oath, basically, in the oath, the witness has to take oath which say he will say the truth, the whole truth, nothing but the truth. For example, in हिंदी, मैं सब भी कहूंगा सच के सिवा कुछ ही नहीं. Okay? Then over here in this room, there is a term which is called perjury. Okay, please be careful with this because perjury is giving false evidence while being under the oath. For example, a person came to you, he took the oath कि हाँ मैं भगवान को साक्षी मान के कहता हूँ कि जो भी कहूँगा सच कहूँगा सब चीज हुआ और कुछ नहीं कहूँगा. And he just rapidly start, laboring false evidences, false fact of it, whatever it is, and that term is called perjury. That term is called perjury. Now, once the oath is done, then start your examination in chief. Examination in chief. Now, basically, examination chief is not a person. Basically, examination chief is like like asking a question, asking the witness like what he saw, what she saw, whatever happened. Okay, but over here we have to make one thing we have to take care is examination in chief is done by the party who called that witness, not the other one. Okay, done by the party who called that witness, not the other one. In this, no leading questions can be leading questions cannot be asked. No leading questions. Basically, leading questions are there which can lead to some scenarios, some facts, or some other things which are related to or which can be related to the scenario or the case or whatever. Okay, this is done. Now, cross examination. With cross examination, this is done by the other party, done by the party, yeah, which is against let me just confirm, or opposition party. Let's not say against, it's just opposition party. And this leading questions can be asked. रीडिंग क्वेश्चंस कैन बी आस्क्ड एग्जामिनेशन चीज में एक चीज बहुत इंपॉर्टेंट है वो ये है कि हम लोग करते थे एग्जामिनेशन चीज बेसिकली हम लोग इसलिए होती है स्टेट ऑल द फैक्ट्स लाइक कोर्ट के सामने सारे के सारे फैक्ट्स होते हैं वट एवर द फैक्ट्स विच आर फैक्ट्स ऑन द यू नो विच इज अंडर इंक्वायरी जो चल रही है चीज वो फैक्ट्स को उसके सामने रखा है कोर्ट के सामने रखा है सारी फैक्ट्स को सारी चीजों को फैक्ट्स को तो क्रॉस एग्जामिनेशन में क्या होता है क्रॉस एग्जामिनेशन जो ओपोजिशन के जो लॉयर्स होते हैं ओपोजिशन पार्टी होती है वो क्या करती है जो भी आपने फैक्ट्स बोले वट एवर फैक्ट्स विच वर टोल्ड by the witness उस पर क्रॉस एग्जामिनेशन करते हैं the basic aim is to give this entire case a new look or to make that person doubt his own you know like whatever he said whatever evidences he gave it is they try to weaken the case. Okay, so this is the cross. Then re-examination. No, in re-examination, this is again done by the party. So calls the witness. So that the main aim is to cross-examination where there can be something which could have mislead the things can which can could have been done uh, basically uh, that could have created some issue with misunderstanding can be present. So, re-examination is basically done to straighten those facts out. Like whatever happened with cross-examination, which is whatever the thing happened with cross-examination, now there is something that is needed to be clarified. So, in the re-examination, the party who calls the witness comes there and then straighten the facts over them. Okay, then there is last one more thing. Yeah, fourth question. Okay, fourth question. Basically, a judge can ask any question at any stage of examination. So once this is done, entire thing, this is how you record an evidence in court of law. If you want to read, you can read it from here, but everything is over. I have provided. Now coming to what is summon. Okay. If you talk about summon, it's a very important topic. Okay, it's a very important because repeated questions have been asked in your practical examination also multiple times. The question is asked by the examiner. So basically, what is the sum? Okay. Now, definition of sum is basically a written document. Please read along, and I want you to make sure that the definition is given that you write uh, in your exam and your practical should be concise, direct, just like the way it is written. It is a written document which is issued by the court, which compels attendance of the witness in court of law on a particular day, on a particular date and time under penalty. Okay, it is basically written document issued by the court, which compels the attendance of a witness in court of law. Basically, एक written document है जो कोर्ट में इश्यू करता है किसी किसी विटनेस की अटेंडेंस के लिए कोर्ट ऑफ लॉ में एक पर्टिकुलर डे टाइम ठीक है ना वी ऑल्सो कॉल दिस एज okay, it comes under section 61, 62, 69 CRPC, DV song. Okay, please verify the DNSS again. I might be, I'm not sharing that because I'm also confused with this. But let's see. It can be, it is issued by the court in writing. It is in duplicate signed by magistrate and bears a seal of form. It is issued by the court, written, duplicate signed by the magistrate, and then bears a seal of form. It is delivered to the witness to a police officer or officer from the court. On getting the summons, the witness keeps a copy and sign back the other copy. Okay. Now, let me just give you a bit overview. What is summons? It is a written document issued by the court which compels the attendance of the victim on a particular day or a particular time. Okay, it is basically written by the court, duplicate signed by the magistrate, and then delivered, and then delivered with the stamp of the court. Okay. And once it's received by you, for example, आपको summon आया है, what you will do? Firstly, you will sign on one copy of the summon and accept the second copy. Okay, who can deliver it? A policeman can deliver it, or a officer appointed by court can summon. Why I'm emphasizing it? It's a very important question. Multiple times this question came in the previous years. Okay, the witness must appear before the court and the specific date time with a proper record. This is very important. You cannot escape from the summon. Else, if you didn't attend, then a proper inquiry arrest warrant can be issued against it. Okay. So until or unless there is a valid and urgent reason of not attending, you need to attend. But now let's say what happens is that आपके पास दो सामान आ गया सेम डेट सेम टाइम what do अगर तो उसकी कोर्ट्स आर डिफरेंट like one is from higher court, one is from supreme court, okay, or lower court, you will say, then then the person should give priority to the higher court. Okay. ठीक? अब आपको एक हाई कोर्ट से आ गया एक आपको सुप्रीम कोर्ट से so you will give your priority to the supreme court. Okay. Secondly, higher court, and secondly, criminal court. You have to give priority to the criminal court over civil court. Okay. What will happen? That the courts are same. For those summon I have, you receive two summons. Both are from civil court. Sorry, high court. But you do whichever summon came to you first, you will attend that summon and also inform the other court. You should also inform the other court. In case of witness fail to attend the court, if there is a valid reason, a message must be conveyed to the court and then the new dates of hearing will be issued to it. But without any valid reason, civil case is liable to pay damages, or a criminal case, court may issue a notice and ask the reason for non-attendance. Non-attendance. Okay. Then, if we talk about medical evidences and all evidences are same. Okay. So basically, what is evidence? A legal mean to prove or disapprove any medical legal finding. Inquiry. Okay. And types, oral evidence and documentary evidence. Oral evidence means all statement which the court permits or requires to be made before it by witness in relation to matter of fact and inquiry. Right? It can be direct, here's your indirect. And what is the medical legal importance? Oral evidence is more important than documentary evidence. As it permits the cross examination. By the perspective of cross examination, oral evidence बहुत ज़्यादा important होता है. The documentary evidence is accepted by the court only after oral testimony of the person is confirmed. Now, exceptions are dying declaration, matter written in the books, evidence given by the witness in lower court, reports of certain scientific expert, public records, and hospital records. Documentary evidence. All documents that are produced for inspection. Okay. Different type of documentary evidences are medical certificates, which are these are issued by the registered medical officer. Example, like fitness certificate, illness certificate, or birth certificate, disability certificate, mental illness, or mental illness certificate. You must retain one duplicate copy of these certificates. It's very important. Medical legal certificates like a report of the injury, wound certificate, reports after examination of the victim of sexual assault. These reports do not serve as evidence until doctor attends the court and testifies the fact under the court. Okay. Now, there is a dying declaration and dying deposition. Very important because in recent examination, the difference has been asked. What is dying declaration? What is dying declaration? We talk about the difference in the further along this part. Okay. It is a written or oral statement which is made by the dying person as a result of unlawful act, leading to his or her death. It can be recorded by the magistrate in the presence of huge party or lawyer. Sorry. Okay. That's the dying declaration. But now dying deposition is same. It can only be recorded by a magistrate and in the presence of huge party or the lawyer. Oath is taken, cross-examination is permitted. It has more legal value, I think, as a bedside court, not followed in dying deposition is not followed in the US. And declaration में क्या होता है कि basically magistrate is allowed to written, obviously. But in such case where magistrate cannot reach that on time, so of course a doctor can take the dying declaration in presence of two, three witnesses. Then get evidence. Get, okay. So now this is an important question. Sometimes can be asked in your act form. Okay. Like, discuss briefly the duties of the doctor in the field while giving evidence. Like, what are the duties while uh, of the doctor while giving the the evidences in the form? So basically, first of all, very important, a doctor should attend the court punctually. Should be punctual. Its office should be well prepared before entering the witness box. It should not be hunting for high reports to field. At least the doctor should have idea कि इन reports में लिखा हुआ है, क्यों लिखा है, what was done, what was not done, why this thing happened. So that witness box में जाके ये ना हो कि बिल्कुल ही that person or doctor can be found. Okay. So second, thirdly, take all the records, relevant reports required for the court. Okay. I should not be like this that you went to the court witness box and then asked upon for the reports you have said nothing. That's not how the food works. You should be punctual. You should take all the actions. Okay, fourth, should be focused. Don't judge me, I'm not. But yeah. You should switch off the phone or keep the phone while on silent. You should not discuss the case with anyone in the court except the prosecutor. You should speak slow, distinctly, audibly, and should use simple language. You should address the judge with the proper title such as Your Honor or Sir. Should not be handy yes or no. Sir or Your Honor. You have to address the judge. You have to give the respect to the judge. You should be pleasant, polite, courteous. Should not lose temper. Should not volunteer any information beyond what is asked until or unless he feels that the answer to the particular question does not reflect the opinion. If he does not wish to make any statement, he can say no opinion and no comments. He should avoid speaking on subject in which he has little or no particular experience. It should not be like this. You're working, you have expert in something else, but you're talking about something else which you have not even single person experience or very little experience. Yes. And again, scenario-based question is there. You guys can just download this book if you want. You can just drop the comments in the book, like if you want. So I'll try again the same. Now, define inquest or what are the type of inquest? Okay. What is inquest? Is basically it is an inquiry or investigation by legal authority into the cause of death where the death is due to unnatural. इसको क्या होता है इंक्वायरी क्या है इन्वेस्टिगेशन जो है एक लीगल अथॉरिटी जो होता है इनटू द कॉज ऑफ डेथ जो अननेचुरल मैजिस्ट्रेट का इंक्वेस्ट होती है बेसिकली देयर आर टू टाइप्स ऑफ इंक्वेस्ट व्हिच आर बीन फॉलोड इन इंडिया अदरवाइज देयर आर one police inquest, magistrate inquest, coroner's inquest, and medical examiner system. Okay, what basically happens is in medical police inquest, police is conducted by police, magistrate is in magistrate inquest, magistrate conducted, coroner's inquest, coroner's conducted, and medical examiner system. No need to, you know, emphasize into it. Just give a main emphasis into this police and magistrate. Police inquest. The investigation or inquiry by the police into the cause of death is called police inquest. Most common type of inquest in India, which is held routinely. Investigation is done by the police officer or investigating officer, not below the cadre of senior head constable. Purpose of police inquest to find out to identify the deceased, place of death, time of death, cause of death. Procedure. Information of that is given to the police. First, the police will receive the information. Then he will inform the nearest executive magistrate in order to proceed for the inquest. Preparation of punchline. Now, investigating officer जो है वो hold करेगा inquiry into content. There are two witnesses. Statement also reported from the family member. Finally, inquest report, which is also known as Panchnama, is prepared. It is then signed by the investigating officer himself and by benches. Okay. In case of foul play, when unnatural death is suspected, investigating officer forwards the body with the postmortem examination with a copy of the request. Then the report is finally forwarded to the magistrate. Okay. Then coming to the next, which is magistrate inquest. Inquiry into the case of death conducted by magistrate is called a magistrate inquest. It can be conducted by executive, magistrate, or judicial magistrate. Now, magistrate inquest is basically conducted with these following issues, these following conditions. Please make sure about this. You have to, like, I have received this question. Here. So, if the death of the person is in prison, death of in police custody, death of person due to police firing, rape in police custody, dowry death, exhumation. What is exhumation? We will talk about this for the part. Okay. Then coroner's inquest, inquiry into the cause of death conducted by coroner. Coroner is basically a person with medical and legal knowledge, the rank of first class judicial magistrate appointed by state law. It is followed earlier in Kolkata and Mumbai, but abolished subsequently. It has been followed by UK, US, etc. Similar to magistrate inquest in quality, coroner is authorized only to conduct the inquest. He is not authorized to conduct trial. Medical examiner system titled conducted in US only. It is a board certified forensic pathologist who visit the crime scene, gather the evidence, and interviews the people to gather information and even conduct autopsy. Best system for the case. No, it's fine. Consent. And what is informed consent? Consent. And one, this is a privileged communication with suitable uh, example. Just let's proceed further with the defining consent. What is informed consent? Discuss about the privileged communication with students. Very important question. Very important question. This is defined consent. It is a voluntary agreement, compliance or permission for some type of consent can be implied, expressed oral and written. Implied consent is basically when a patient comes to a doctor. Patient doctor को सर वो ना डॉक्टर के पास आने के लिए कंसर्न रहेगा कि हाँ मैं बताऊँ आपके पास आने या फिर डॉक्टर को कहेगा हाँ ठीक है कि आप मेरे पास आए, मैं हाँ मेरे को आंसर लिखना है मेरे पास आए तो जनरल मेडिकल एग्जामिनेशन फीचर it is not expressed in word but basically not written form in it include it itself. It is limited to few things, that is inspection, meditation, consultation and hospitalization. जो implied consent है ऑटोमेटिकली implicate हो जाती है आपकी सिंपल जब वो आपके पास इसकी लिमिटेड क्या है कि आप इसको हॉस्पिटल कर सकते हो, इंस्पेक्ट कर सकते हो, palpate कर सकते हो, question कर सकते हो, beyond that. Express consent is a consent which specifically expressed by the patient. That is expressed by the patient. Oral consent is that for minor procedure. Written consent for major diagnostics procedures and general anesthesia. Okay. Now, informed consent. It's also called doctrine of informed consent. Doctors should explain the condition of nature of things, the need of diagnostic tests to be done, all treatments option, all the alternative procedures, risk benefit ratio to the procedure, okay, prognosis of the treatment, duration of the treatment. The person should be, the doctor should explain all this. Like कैसी condition है, nature क्या है, illness की, patient की, कौन से diagnostic tests हैं जो हमें चाहिए करने चाहिए, all the treatment options, जो जो treatment options हैं, and alternative procedures, risk benefit ratio क्या है कि हाँ इसको आपको इतना risk है, आपको इतना profit हो सकता है, benefit is association, associated complications or consequences, prognosis of the treatment, and duration and treatment cost. It should be in simple and proper language. So the patient can decide if he or she want to undergo patient the treatment or not. It is up to the patient to undergo the treatment or procedure. Exceptions in case of emergency, obviously it is your right to, first of all, save the patient first. Okay. Therapeutic privilege, basically, doctor feels a full disclosure to the patient can cause an anxiety, then the doctor can disclose the full information to any other family member. Okay. For example, cancer. Therapeutic waiver. The patient waives full faith to doctor may waive his or her right for informed consent. जब अब पेशेंट आपके पास आया, बहुत पुराना पेशेंट है, उसको पता है कि आप कुछ गलत नहीं कर, उसने कहा कि हाँ डॉक्टर साहब मेरे पास आपकी फुल अथॉरिटी है, आप जो भी करना चाहो जैसा भी करना चाहो मेरे को पूरा फेथ है, मैं कोई इंटरवेंशन नहीं भी सकती आप, ठीक है. Prisoner, convicted person who has no right as any responsibility. Medical examination requested by a police officer for arresting accused under section 53 or PGVRP. Treatment of notifiable disease in the community interest and medical legal postmortem. इसमें तो क्या ही आप लोग है ना, पोस्टमार्टम में लास्ट को अपने पोस्टमार्टम करते हैं, so that is due to a suspicion के अंदर ही आया हुआ आपके पास सोर्स पता नहीं. अब now what are the rules of the consent? It should be free. Now I'm going to speed up a little. It should be free, voluntary, clear, okay, clear, and there uh, should not be any undue influence, fraud, misinterpretation of all the procedure beyond routine physical examination requires express the consent. When the written consent is obtained, it should also be signed by some other witness. In case of children less than 12 years of age, case of insane person, the consent comes from the parents or parents. As per the Section 90 IPC, consent given by insane or intoxicated is non-valid. And in case of emergency, if the patient is unconscious and no guard is available to give consent, the doctor can perform emergency procedures or surgery without the consent. It is essential to save the life of the patient. Any person more than 80 years of age can give valid consent. Okay. Consent given for a radio diagnostic or diagnostic procedure cannot be considered as consent for therapeutic treatment. अब ये नहीं कि हाँ आपने बोल दिया ठीक है आपका HIV का टेस्ट करवा देते हैं या फिर मलेरिया का टेस्ट करवा देते हैं, तो टेस्ट करवाना और ट्रीटमेंट करने को आपने कंबाइन नहीं करना. That is both separate entities. Consent for diagnostic procedure and for the treatment is not the same. It's different. इसके लिए आपको differently you have to take the consent. No consent is required in case of medical legal adoptions. Consent for the both partner is required for contraceptive sterilization and artificial insemination. Pregnant female alone can give consent for termination of pregnancy. Husband or wife has no right to deny the treatment of his or husband. For examination of victim of criminal case, it's, it's mandatory. Consent is mandatory. Coming to the privileged communication, definition of privileged communication really, disclosure of confidential information by the doctor to the concerned public authority due to its legal, moral, or social duty to protect the interest of the community. It is an exception of the professional secrecy. Doctor has a moral duty to keep the information up to the illness of his patient secret for confidential. But उसकी moral duty भी है तो community interest को भी protect करेगा. So here privileged communication plays an important role. So doctor will not be liable to damage because it is the interest of the community. Example, court of law, civil benefit, it's a, okay, the venereal disease. You can just go through this. It's very important. Okay. If you have the patient can trust me, like doctor may disclose patient's condition to a relative. You can notify disease like in case of infectious disease, epidemics या food poisoning के केस में public authorities को बताना होता है. Suspected crime के केस में like homicidal poisoning and all के केस में बताना होता है. Venereal disease में जो treating doctor है, ठीक है ना? It is the treating doctor has advised him not to marry till cured. If the patient refuses, the doctor can disclose a detail to the disease or to the other party also. सिविक बेनिफिट में क्या आएगा कि अगर मान लो कि एक कार ड्राइवर है वो अपना फिजिकल करवाने गया लेकिन उसको अल्कोहलिज्म का इश्यू है एपिलेप्सी है या ड्रग एडिक्शन है कलर ब्लाइंडनेस डॉक्टर उसे एडवाइस करेगा कि चेंज द एनवायरनमेंट बिकॉज ये डेंजर है फॉर द प्रेजेंट कम्युनिटी ऑक्यूपेशन बोथ हिमसेल्फ टू अदर पार्ट अदर पब्लिक अगर वो रिफ्यूज करे तो वो ये इंफॉर्मेशन डायरेक्टली कंसर्न अथॉरिटी से डिस्क्लोज कर सकते हैं इम्प्लाइड कंसेंट बताई गई आपको सुविधा कॉन्ट्रीब्यूटरी नेग्लिजेंस. It is unreasonable conduct on the part of the patient attendants, which is combined with doctor's negligence, contribute to the injury complaint of or as a direct cause. Patient contributes to his negligence when fail to show doctor's instruction regarding medicine, sorry, fails to give proper medical history to the doctor, fails to follow up. For example, given the tight plaster cast on the patient's hand. Doctor's negligence. As a result, the patient develops numbness of his finger, which, but he did not inform the doctor. Consequently, he suffers from permanent injuries as a result of formation of the gangrene. Limitation क्या है? Last clear chance है doctor को. And avoiding consequence. It is a good defense of doctor in civil cases, but burden of proof lies with the doctor, not a defense in criminal cases. Perjury already informed you. Willfully giving false evidence under oath. Punishment, imprisonment up to is 7 years. Reason behind it क्या होता है कि यहाँ तो उसने bribe ली है. Either the witness is to bribe, or maybe he is under threat or personal bias towards one. Now, I would like to emphasize it more because in my final examination, I received in the this question, rest is qualified. The outline of rest is qualified means the things of the facts speak for us. Normally, in the case of the professional users of the doctor, burden of proof lies on the patient. But in some cases, where rule of rest is qualified of lies, the negligence is so gross and obvious that the patient does not need to prove any negligence. Now, this thing happened that the patient, the doctor was supposed to amputate this arm. Okay, but he did this one. Like he was supposed to do the left one, but he did the right one. So usme the fact speaks for itself. That's a very gross negligence. So the patient does not have to give any proof. It's this fact of the fact speaks itself. The doctor has full control over the treatment instrument. The doctor had it. The patient is not found guilty in the contribution. Privilege communication done. Any question done? Please make sure to go through this. This is not that important, but I would suggest you it's kind of an important topic. Listen, an employer is held responsible for, oh, sorry, okay, vicarious liability, which is doctrine of respondent superior. It is defined as the employer. For example, the employer is held responsible for negligence act done by his team. For example, if there is a nurse working on leave, okay, something that nurse did, okay, which caused some issues to the patient. Now, you, as an employer of that nurse, is also held responsible for the negligence done by her. Okay, this term means let the master answer. So the captain of the ship doctrine, chief surgeon, and okay, under the hospital is responsible for all the negligence of his employee who is acting under the supervision and control. Okay, the application of this is employee-employee relationship. The employee's conduct should be within the scope of employment. The act should not occur while should have occurred while on the job. Examples you can. Okay. This is an important question. Various courts and the top court, Supreme Court, highest court in the country, can pass any sentence, including that, can be fined unlimited. Second court, high court, second court, the highest court in the state, can pass any sentence, including the sentence, unlimited fine people, the court can. But the death sentence given by the session court is confirmed. By Session court, highest court in district, can pass any sentence, including death sentence, but forward it to the High Court for confirmation and fine unlimited. Coming to the magistrate. Magistrate courts are further divided into Chief Judicial Magistrate, Judicial First Class Magistrate, and Judicial Second Class Magistrate. Now, Chief Judicial can accrue 7 years of imprisonment unlimited from Judicial First Class, 2 3 years of imprisonment and up to 10,000 to fine. Judicial Second Class, basically 1 year of imprisonment and 5,000 to 5,000 rupees. So that was bank declaration. I have already informed you. Bank deposition I've already informed. Now, leading question can be an important question. Any question or suggesting the answer which the person putting its wish or expect to receive, like any question जिसका कोई आंसर हो सकता है जो एक person put कर सकता है by its wish or expect to receive. The answer of the leading question is either yes या no. ये नहीं कि हाँ ओके ठीक है yes या no. कत्ल किया yes या no. आप कत्ल होता देखा yes या no. Did you saw this person committing a crime or yes yeah, that is conduct only. It's important. Definition of conduct money is a fee paid to a witness in civil cases at the time of serving the summon to meet the expense of attending the court. Basically, ये fees है जो कि witness को pay करते हैं in civil cases only at the time of serving the summon. Expense summon to meet the expense of attending the court. If the conduct money is not sufficient or not paid, it can be brought into notice by the court before giving evidence, and the court will decide the amount. In criminal case, no conduct money is paid to at any time of serving a summons. The witness must attend the court in interest of state of justice. However, government pay should pay the allowance. Professional death sentence already informed you, like it's complete permanent removal of the name of the document from the state. Okay. So, so differentiation. Examination in chief. First statement which is recorded by the prosecution lawyer or the party who touched. So, observing statement which is recorded by the lawyer of accused party or opposition party. Reading was not allowed. Order of sequence, oath is followed by examination, and then order, examination chief is followed by process. Object to place before the court all these facts to bear the bears of the case. To elect facts favorable in his case, test the accuracy of the statement and to discredit the witness. Bank declaration, important, very important. Bank declaration, oath is not required, direct acquisition must. Recorded by anyone magistrate or police officer. Bank deposition, only one nation. Accused party not allowed, bank deposition, yes. Prosecution not allowed, here, yes. Followed in India, yes. Lost its value if the person's wise, value is retained in bank. Type of evidence documentary. Bank deposited, poor. Role of doctor, assess compos mentis and record the statement in absence of magistrate but the presence of witness. Assess compos mentis like, is if the person is like in full in his full state of mind to give the this or not. This I've already informed you. You can just go through it once. Just take a screenshot. You just go through. Professional misconduct and professional negligence. Okay. So guys, let's end this session on this first part of this video. Okay, I'll try to upload the rest of the part soon on the channel itself. And with this, will I will ask you to just go through with your important Vishwas book once again. It's a very good book. You just go through it and just revise it. I hope that the first chapter is, I have cleared a few questions, a few topics from the first chapter itself. It's a sincere request to everybody that please do not judge my teaching. I am just trying to, teach you with the basic knowledge so that even a basic person, new person with some knowledge can just go through with this and understand what I'm trying to say, and they can, just uh, study and give his best. So that was